Okay, I just want to move on to the question of bogus self-employment. Do you have any estimate, or have you done any work, or do you do any work to establish what is the loss to the public, in terms of the public purse, as a result of so-called bogus self-employment?
Oh, like I've been at this committee and I've been at the PAC talking about bogus self-employment for the last 5 years, and we have to be careful on bogus self-employment has a cachet. There are various different forms of employment, self-employment, working relationships over the while. We pay particular attention to it. We do a significant number of real-time business visits, site visits, interview probably thousands of people every year in relation to their employment status on the construction sector and other sectors. I mentioned in my opening statement about the report, the review. The review tried to put a framework about the potential social insurance and tax loss if certain scenarios. But I think I suppose the real challenge is that the nature of what that bogus self-employment is now mostly done through different corporate structures. The personal service companies, the managed service companies, and the idea, we do not have look-through provisions to look through a limited company. And one of my colleagues was telling me about their nephew who's starting work in a particular sector recently, and they signed various documents, including establishing themselves as a limited company. This was the terms of engagement. That's not bogus. That's not bogus self-employment. That's a legal corporate structure. And if we want to have a provision to look through that legal structure, change has to take place in the law. We did, and it was subject to study by the Controller and Auditor General, our contractors project a few years ago, where we looked at that particular personal service companies and managed service companies, and there was challenges around overclaiming of expenses, etc., etc., etc. But the one thing that we weren't looking at is looking through the corporate structure, the limited liability structure, and things flow from that. The report, and this report is paralleled with the work that the Taylor Commission did in the UK. There has been recent cases in the UK which have looked through, because they have provisions to allow you to look through. But I suppose the big challenge is that there is a fiscal advantage from having the self-employed structure in relation to employers' PRSI. That's the monetary driver. There are other drivers, and I don't need to tell you about, because I know that you've paid close attention to the whole area over the last number of years. There are different workers' rights involved, which sometimes are a driver in some of this. And then the nature of what employment, self-employment, it ranges from people who are in it's very advantageous, they're high earners, are in a particular structure. And then there are, and we would have seen it probably more so as the recovery started in some of the more precarious sectors. But as like obviously an area we pay close attention to is the whole construction sector, where the subcontractor model is a well-established and very positive for those who are subcontractors. But certainly as the construction sector started to come back in about 2011, 2012, we would have had a lot of complaints around bogus subcontracting. But as the construction sector has improved the nature of that changes, in that the relationship becomes different, the power relationship. So we pay a lot of attention. We reclassify people. We will respond to information. We will interview. But the issue around addressing corporate structures is really a legislative issue.
Okay. I mean, I was at a committee recently with DSP, and they said they don't keep any stats for the amount of cases of bogus self-employment today, because they're dealing with one end of the kind of problem, you're dealing with another end of the problem. You obviously don't have very definite figures or estimates about what is lost. ICTU had a report which suggested that in construction it was 80 million per year, 640 million since 2007. There are other estimates which are substantially higher. I mean, you rely on in your opening remarks on the report from DSP, but like you say, it's kind of, the report says, well, if it's this, then it's that, but it doesn't really say what things actually are. But to what extent are you investigating and looking at this problem? I mean, I saw a report in the paper which suggests that at the end of 2016, you did about 18,000 inspections and got 54 million between back taxes, fines, etc., which came from some form of bogus self-employment. Can you put any sort of figure on this whatsoever?
I can actually set out the various figures where we reclassify a number of people as a result of work we do. If you just give me a bit of time, and I'll come back to you with before the session is
okay,
out.
Great. Yes.
But what I suppose a couple of the things on the aggregate level, the growth in self-employment. There's no evidence that there is a significant increase in the number of what would appear to be employees who are self-employed. There was, over the last 10 years, a growth in personal service companies and managed service companies. And there are a number of companies whose business model is establishing those type of processes. And we found it really interesting. And there's thousands of those companies. And a lot of people are absolutely perfectly happy to be in that. They've gone into a director position. But I must say, I was, when we started looking at the contractors, I was fascinated by some of the managed service companies where you have generally 6 directors. Often the 6 directors do not know each other and might be different. They tend to be professionals. And essentially it's a different way of providing that model. The other issue is the whole gig economy model. You will be aware that recently we had an appeal commissioner's decision in relation to an employment of, and it's published around delivery, where we challenged the employment status, and that we were successful in that. But the reality is, Deputy, that in a lot of those areas, the contractual arrangements are such that unless either party of the contract decides to tell us that it is not a viable, it's not a legitimate contract, we cannot generally be able to overthrow it.
Well, sure, just to finish with one specific area then, which is the area of couriers, because I understand that there was a meeting back in, I think it was 1997, with representatives of the courier industry who were seeking to have couriers in general classified as self-employed as opposed to employees. And so that was a case where you weren't just waiting for someone to present themselves, but in fact had pre-discussion with the industry, let's say, rather than employers, if you want. I just draw your attention to a note on the taxation of couriers, document of dated November 2018, which says that, as an appendix 1, question, how are couriers treated for tax purposes? Couriers are regarded as self-employed for PRSI purposes as a result of the SWAO's, Social Welfare Appeals Officer's decision. In the interest of uniformity, Revenue decided without prejudice to treat them as self-employed for tax purposes. Is that not problematic in the sense that certainly some couriers may well be self-employed, but many couriers have a relationship that ticks the boxes of employer-employee. They've been working with the same company for a long period of time. The employer sets the terms of employment. They have very little control over their employment, and it suits their employer, obviously, that they are classified as self-employed. How can Revenue justify saying that for the purpose of, in the interest of uniformity, that you, as a baseline point, treat them all as self-employed as opposed to investigating each particular set of circumstances? Thanks.
Like, I know that there's been a lot of commentary about the Courier issue when we issued the guidance, but it actually does depend on the particular circumstances. And if somebody is specifically an employee, they can have employee status, but it has to be in the context of the circumstances. And there's two parties involved in it. And in a way, that's why in that particular delivery company, we challenged the case for the particular circumstances, and we were successful in that. And I know that we talk at various committees about the Tax Appeals Commission, but one of the things I think that's really interesting is that the Tax Appeals Commission's decisions are now published for the last few years, and that sets out where we did challenge because we felt that the circumstances were such.
The idea of, in the interest of uniformity, treating them all as self-employed, where does that come from? How can that be justified? As I understand it, there's no such thing as test cases in the sense that every case has to be looked at individually because the circumstances are individual.
See, in a way, ultimately, the Department of Social Protection have the lead role in relation to setting out the employment status, and scope section will look at it. Social welfare officers determined originally the status. We try as much as possible to have a shared common view between ourselves and DSP. Not all the time, but by and large, because again, the social insurance becomes a driver. We're an agent for DESP and the collection of PRSI. It sometimes depends on the role of what the delivery driver does. In where you're involved in doing other work in addition to delivery, loading, unloading, we will look at areas like that, and that becomes central to the case we were involved in. So it is a really challenging area. I think that we have the code of practice, but the code of practice is guidance. There has been significant changes in legislation in the intervening period in the UK. That doesn't mean that they have sorted this problem. This problem is not, to the extent that it's a problem. The changing nature of employment is also part of it. And there was a really big case in the UK recently, and I remember it got covered in Panorama or Newsnight, and involved the plumbing industry. And everything was very fine until the particular person who won their case had an accident at work. Everybody was very happy with the arrangement, very high earners, but when the difficulty then ran into the health entitlements, and that case has gone, I think, through all the courts in the UK. So the particular facts of the case are really important. We try and follow the line of DSP because it's social insurance contributions and entitlements. The overall numbers would suggest that there hasn't been a massive increase, but in sectors it is a practice of, and I think that the issue is very much around moving towards that limited company type process rather than a self-employed, as we would call them, Schedule D person. And if there's a Schedule D type operation, and it's very easy to turn that into a limited process, and we do not have that look-through provision in Irish legislation.
Thanks.
Deputy Burke.
Thank you.